Well, good afternoon. This hearing of the Subcommittee on Commodity Exchanges, Energy and Credit regarding reauthorization of the CFTC as it relates to market participants' views will come to order. Thank you for joining us for our second meeting of the Commodity Exchanges, Energy and Credit Subcommittee of the House Committee on Agriculture. Yesterday, we kicked off the work of this new subcommittee by hearing from several representatives from the community of derivatives and end users on their thoughts regarding the CFTC reauthorization process this committee will be undertaking in the days ahead. Today, we will continue that examination with a focus on perspectives from futures and swap marketplaces. We are fortunate to be joined by a panel of distinguished witnesses who are here to share their perspectives as derivatives market participants. The industry is well represented today by two of the largest derivative exchanges, a key self-regulatory organization, and two important industry trade associations. We hope to come away with a greater understanding of the challenges that each of them face. Derivatives markets have changed in the 5 years since the passage of Dodd-Frank, both because of and in response to the new rules written by the Commission. Many of the witnesses before us today have seen daunting changes in regulatory burdens and business practices, perhaps none more so than Mr. Bernardo, who testified in front of our committee a little over 4 years ago in February of 2011. At that time, the rules governing his soon-to-be CEF had not yet been written. They wouldn't be proposed until June of 2011, and they were not finalized until August of 2013. In the 18 months since the rules were finalized, the CFTC still has not finalized the registration of a single SEF. Mr. Bernardo has seen the entire process of creating the SEF rules structure rise and set, and yet he is still facing considerable uncertainty about the business he operates. Likewise, the further into implementation we get, the more cross-border jurisdictional issues that seem to arise. Today we will hear testimony from 5 witnesses, 4 of whom will mention the confusion and difficulty they are facing following competing, often conflicting rules for these international markets. The continuing uncertainty and ambiguity in the rules, compounded by the sweeping nature of these regulatory changes, pose challenges for the witnesses before us today and their customers, the end users who rely on access to derivatives markets. My goal throughout this process is to ensure that we have a healthy balance between market integrity and market access. Derivatives markets exist for those who have a need to hedge. Hedgers need markets that are safe, but also need markets with affordable execution, available counterparties, and consistent liquidity. This subcommittee will continue to look for that healthy balance. Thank you to the witnesses for appearing before you today. We look forward to hearing your perspective on these issues, and I appreciate the time and effort that you've put forward to be here. With that, I'll recognize our ranking member, Mr. Scott, for any comments that he may have.
Thank you, Chairman Scott, and it's indeed a pleasure to have these distinguished witnesses before us. As we all know, derivatives is just an extraordinarily exploding, growing sector of our world economy. It's right up there now around $900 trillion worth of the world's economy. It's a very complex, complicated issue. There are many issues that we need to address as we go through this reauthorization. Paramount, of course, is to make sure that the CFTC has adequate funding to do the job. If that's not in place, then we create another series of problems that prohibit us from having a clear vision of where we need to go. So I am pleased that we're continuing a strong series of hearings to discuss the reauthorization of the Commodities Exchange Act. And as I mentioned yesterday, in the last Congress, we put together a very good bill, a very robust bipartisan package. That was H.R. 4413. Unfortunately, it passed out of here by voice vote. It passed on the House floor, but the Senate did not take that up. And we refer to it as, of course, the Customer Protection End User Relief Act. It's common sense legislation, and we need to continue to move in that direction with new legislation as quickly as we can. So this year, we're going to put forth a bill that basically mirrors much of what we had in H.R. 4413. And yesterday, I highlighted some of the essential points that are related to our end users and the critical component of providing much-needed clarity and easing some of the unnecessary burdens which include reporting requirements. And it's very important that we realize that many of our end users, most of which had nothing to do with the financial meltdown, and certainly we need to look with a very clear, jaundiced eye to make sure that we're not putting them at a competitive disadvantage without understanding that differentiation. So today I'm pleased that we have representatives of our market participants, very fine exchanges that we worked with over the years, and I'm confident that we will have a very productive discussion regarding the authorization of the Commodities Exchange Act. So, Mr. Chairman, I look forward to hearing from our witnesses regarding their thoughts on last year's bill, any improvements that you think we can make going forward that we can add to what we did with 4413, areas of interest that may require further examination. You all, our market participants, you're the ones that have to make this work. So we can make the law, but you're the ones that have to make it work, and so we're very interested in having a very candid, forthright conversation, two-way with you as to how we can certainly improve the situation. There have been points of concern that have arisen to include personnel location tests, the European Union's recognition of U.S. clearinghouses, the U.S. recognition of foreign clearinghouses, cross-border guidance, and the U.S. person definition, to mention certainly just a few. And so, Mr. Chairman, I was very pleased when we dealt with many of these issues in H.R. 13, and I am very confident that we will address them again in a very bipartisan issue. And finally, Mr. Chairman, I want to reemphasize my call that we really strengthen the CFTC and give the agency the adequate funding that they need and support that is required in order for the CFTC to fulfill its mandated mission, which is to protect market users and their funds, consumers, and the public from manipulation and abusive practices related to derivatives. We've got an awful lot of issues that are still out there, cross-border, even down to the push-out, to make sure that we're doing the proper thing. And the CFTC is that arbiter there. It's very important that where possible, where we have to make joint rules between the FTC and the SEC, that go forward. So we have quite a bit on our plate. We're looking forward to a very interesting hearing. Thank you very much for coming, and Mr. Chairman, I yield back.
Thank you, Mr. Scott. The chair would request that other members submit their opening statements for the record so the witnesses may begin their testimony and to ensure that there is ample time for questions. The chair would like to remind members that they will be recognized for questioning in order of seniority for members who were present at the start of the hearing. After that, members will be recognized in order of their arrival. I appreciate members' understanding. Witnesses are reminded to limit their oral presentations to 5 minutes. All written statements will be included in the record. I would like to welcome our witnesses to the table, Mr. Terrence Duffy, Executive Chairman and President of CME Group, Chicago, Illinois; Mr. Benjamin Jackson, President and Chief Operating Officer, ICE Futures, U.S., New York, New York; Mr. Daniel Roth, President and CEO, National Futures Association, Chicago, Illinois; Mr. Gerald F. Cochran, Chairman of the Board and Chief Executive Officer, R.J. O'Brien and Associates, LLC, Chicago, Illinois, on behalf of the Futures Industry Association; and Mr. Shaw Bernard, Chief Executive Officer, TP-SEF, Taunton, Preben, Jersey City, New Jersey, on behalf of the Wholesale Market Brokers Association of Americas. Mr. Duffy, please begin when you're ready.
Thank you very much, Chairman Scott and Ranking Member Scott, and members of the committee, for allowing the CME the opportunity to present our perspective on the CFTC reauthorization. I've addressed several things in my written testimony, but today I have one overriding issue. It's among the most critical facing the U.S. derivatives markets today. It can be summed up in just one word, and Mr. Scott said it a moment ago, which is equivalence. Under European law, U.S. clearinghouses and exchanges like CME must be recognized by their European regulators. This recognition can only happen if the European Commission first determines that the regulations in the United States are equivalent to European Union regulations. Without these actions, European clearing firms and market participants will be subject to a prohibitive cost if they clear or trade in the United States, or they may be denied access to U.S. clearinghouses and exchanges altogether. This could harm U.S. clearinghouses and exchanges competitively. It would also harm both U.S. and EU market participants. It would drive down participation in U.S. futures markets. It would reduce liquidity. It would impede the ability of farmers, ranchers, and other U.S. and EU businesses to conduct critical risk management needs. Because no prudent business wants to be caught in a regulatory game of chicken, we are already seeing firms taking steps to consider alternatives outside of the United States. After more than 2 years of negotiation and delays, the European Union has refused to grant the United States equivalence. Since his arrival at the CFTC, Chairman Timothy Massad has been a tremendous leader in working towards a solution that avoids market disruption and affords U.S. and foreign-based markets equal flexibility. Yet the European Union continues to hold up the U.S. equivalence determination over a single issue, our margining standards, while at the same time they have approved other countries, including Singapore, which uses the same margining standards we do in the United States. The United States should not be required to have identical margin standards to the EU. The specific U.S. margin standards in question are an important component, but not the only component, of a robust regulatory structure under the CFTC's oversight. What is puzzling is that the U.S. rules generally require equal, if not more, margin to be posted with clearinghouses than they do in the European Union. We call upon the European Commission to take a balanced approach. It should allow the United States and Europe to recognize each other's regulatory regimes, including margin rules. Time is of the essence. On June 16th of this year, if the U.S. is not granted equivalence, U.S. clearinghouses will not be deemed qualified central counterparties under European law. As a result, customers will be subject to significant and inappropriate capital cost if they are to use U.S. clearinghouses. Furthermore, a European clearing mandate, which is similar to our Dodd-Frank mandate, will also go into effect in the fourth quarter of this year. Without the U.S. being recognized, European market participants will be prohibited from using U.S. clearinghouses to clear mandated derivatives. Today, the CFTC rules and policies grant European-based foreign boards of trade and clearinghouses full access to the U.S. marketplace. At the same time, the CFTC has many tools at its disposal to deny such generous access. For example, the CFTC could terminate the no-action relief under which foreign boards of trade are currently operating in the U.S. I hope this does not prove necessary, but all options must be considered at this time. We urge this committee to take any and all appropriate actions to support the CFTC's position and reach a solution as soon as possible. There's one other issue that I'd like to mention today, and that's the threat to how commercial market participants manage their risk. The position limits proposal that is currently pending before the CFTC would impose overly narrow restrictions on the hedging and commercial market participants. It would limit them to a narrow list of transactions. This approach would prevent businesses from continuing their traditional hedging operations. It would introduce unnecessary risk and costs which could ultimately fall upon the consumer. There is a simple solution, however. The rule should be amended to accommodate all reasonable commercial risk reduction strategies that satisfies the statutory criteria. This flexible approach would recognize traditional hedging practices. It would also prevent the Commission from needlessly tying up its limited resources. I want to thank the committee for its time and attention today and look forward to answering your questions.
Thank you, Mr. Jackson.
Chairman Scott, Ranking Member Scott, I'm Ben Jackson, President and COO of ICE Futures US. I appreciate the opportunity to discuss the reauthorization of the Commodity Futures Trading Commission. And I'm going to comment today on two specific topics. First, ICE Futures US and our self-regulatory functions. As background, ICE Futures US is a designated contract market owned by the Intercontinental Exchange, which is the leading global network of regulated exchanges and central counterparty clearinghouses for financial and commodity markets. ICE Futures US has a strong history of overseeing position limits, accountability levels, and exemption requests. Our market regulation teams employ decades of surveillance and compliance expertise in working with the derivatives markets and the derivatives markets participants that they oversee. This extensive, direct experience has guided our self-regulatory functions. In particular, the rules and procedures developed and used by our exchange to perform this important function were designed to incorporate the specific needs and differing practices of the commercial participants in each of our markets as those needs and practices have developed over time. In revisiting the CEA, the committee should encourage the CFTC to re-examine the position limit proposal and in particular the effects of narrowing the definition of what qualifies as a bona fide hedge and the move toward hard position limits in the non-spot month. For administering hedge exemptions, given the CFTC's constrained resources and the significant time and resources that such an undertaking would require, we believe that the existing current structure reflects an efficient allocation of resources that ensures commercial market participants will be able to continue to hedge their risks in a timely manner. In regard to position limits in the non-spot months, the current accountability regime has proven to be effective at balancing liquidity in nearby month expiries and future month expiries. We believe that the current regime is effective from a resource standpoint and has proved to result in well-functioning markets. Therefore, the current regulatory regime, which is overseen by the CFTC and incorporates rules subject to CFTC review, should remain in effect. The second topic I want to touch on is where we are, in my view, on global financial reform efforts. Over the past 2 years, regulators in the United States and Europe have been working to address conflicts in the two major financial reform efforts, Dodd-Frank in the U.S. and EMIR in Europe. ICE Futures US appreciates the hard work that the CFTC and its staff, as well as their counterparts in Europe, are putting into achieving true equivalence. The derivatives markets are global, and in addressing these conflicts, we encourage regulators to reach this equivalence. Widely varying rules will only serve to increase complexity for the people that use our markets every day. The CFTC has historically relied on foreign regulators to regulate foreign transactions and worked with regulators to adopt common principles that all regulated markets should adopt. European regulators took a similar approach to U.S. markets. This approach was very successful as it led to a greater harmonization of regulation, yet allowed foreign regulators to oversee their institutions. We strongly encourage a return to this approach. In conclusion, I would like to note our appreciation of Chairman Massad and the CFTC's efforts to address many of the issues that I've noted today through re-examining some of the rules affecting the futures markets. We also appreciate the efforts of this committee to re-examine the CEA and the impact of Dodd-Frank. Thank you.
Mr. Roth.
Thank you, Mr. Chairman, and thank you very much for the opportunity to appear here today. This committee is taking up the issue of reauthorization at a particularly critical time. Implementing all the changes mandated by Dodd-Frank has been very challenging for regulators like NFA, and I'm sure even more so for the members that we regulate. What I'd like to do this morning, or this afternoon if I could, would be to describe briefly some of the changes we've made at NFA to cope with those changes, and also talk about a couple of provisions in last year's bill that we strongly advocated last year and we continue to support this year. At NFA, the one thing that hasn't changed at NFA is our basic mission. To put it in a nutshell, our job is to help the CFTC. We're the industry-wide self-regulatory body. Regulation is all we do, and we're there to help the CFTC. We do that in a number of different ways. For example, in certain areas, the CFTC actually delegates certain responsibilities to NFA. And in those areas of delegated responsibility, NFA acts as an agent on behalf of the CFTC. So, for example, the entire registration process, the CFTC has delegated that to NFA, and we act on behalf of the CFTC. Similarly, for commodity pool operators and commodity trading advisors, they're required to submit their disclosure documents to the CFTC, while NFA reviews those documents on behalf of the CFTC. Pool operators will submit 5,000 financial statements to us within the next few weeks for the pools that they operate, and those are required to be submitted to the CFTC. NFA will review those on behalf of the CFTC. In other areas, though, we don't act as an agent for the Commission, but rather as a self-regulatory body like the CME and ICE and others. And in those areas, we basically perform examinations of our members and take enforcement actions when necessary where we find members not in compliance with the rules. In that area, I think the biggest change that has occurred in NFA involves swap dealers. Dodd-Frank required swap dealers to register with the CFTC. The CFTC, in turn, required them to become members of NFA. So over the last 4 years, I should mention we have about, I think, a little over 100 swap dealers right now. And over the last 4 years, we've basically had to build from scratch a self-regulatory infrastructure for those swap dealers. So we have added, our staff is almost 100 now, devoted solely to swaps compliance. We have a staff of almost 100. We're projecting additional hiring in our next fiscal year. Those people have been very busy. They've been busily engaged in reviewing hundreds of thousands of pages of policies and procedures that those firms were required to submit to the Commission, and we reviewed on the Commission's behalf. We've also prepared examination modules for each of the rulemaking areas where the Commission has completed its rulemaking, and we've begun performing on-site examinations of those members to monitor them for compliance. All of this, as you might gather, has had a pretty significant impact on our resources. Our staff over the last 4 years has grown from about 300 to 480, and again, we're projecting further growth next year. Our budget has more than doubled from about $42 million 4 years ago to, I think it's going to be over $85 million in the next fiscal year. Those are pretty dramatic increases, but our board felt that each and every one of those increases in our budgets was mandatory, was essential for us to carry out our function. With respect to last year's bill, if I could just mention briefly, there were a couple of provisions in last year's bill that were very important to us from a customer protection point of view. One of them involved FCM insolvencies. The CFTC a long time ago had adopted a rule that provided that if an FCM was in bankruptcy and if there was a shortfall in segregated funds, then customers received priority over all the other creditors of the FCM. And that was a good rule. That rule has served the industry well, it's served the customers well. Unfortunately, a few years ago, a lower court opinion cast some doubt on the validity of that rule. The court had questioned the CFTC's authority to adopt the rule that it had adopted. Last year's bill contained language to clarify that point and to make clear that the Commission did have the authority to adopt that rule. We supported that rule, that provision then. We support it now. We hope it's in the bill that comes out of this committee this year. There were also some significant customer protection provisions in last year's bill codifying some of the work that NFA and CME and others had done with respect to the daily confirmation of customer segregated funds, increased transparency about FCM financial data, and other matters along those lines. And that was included in the bill. We support codification of those provisions and hope they're included again this year. Mr. Chairman, I'd be happy to answer any questions. Thank you very much again for the opportunity.
Thank you. Mr. Corcoran.
Chairman Scott, Ranking Member Scott, members of the subcommittee, thank you for the opportunity to appear before you today. I'd first like to commend the Agricultural Committee for continuing the bipartisan approach to developing legislation. It is a spirit that resulted in the House passing a good CFTC reauthorization bill during the last Congress, and we look forward to a collaborative bipartisan process again in 2015. The reauthorization legislation developed by the House Agricultural Committee during the last Congress contains several customer protection enhancements that FIA continues to support, including two key clarifications, one relative to the timing of an FCM's residual interest obligations, and another restoring legal certainty as to the utilization of property outside of the segregated customer accounts to ensure that customers are the highest priority in the event of an FCM bankruptcy. In addition to the recent customer protection improvements, The entire clearing ecosystem has undergone major regulatory changes since enactment of the Dodd-Frank Act in the U.S. and EMIR in Europe. When policymakers determined to extend clearing beyond futures and options to certain over-the-counter swaps, the role of the FCM also expanded. FCMs play a critical role in ensuring that cleared transactions are secured with appropriate margin to facilitate this clearing process. We operate in global markets, and if global regulations are not well coordinated, the markets will fragment within regulatory jurisdictions and become far less liquid to the detriment of the ultimate end users. I'd like to highlight one global regulatory coordination challenge we are currently facing. Europe and the U.S. have developed differing requirements relative to margining methodologies that clearinghouses must apply. As clearing members of clearinghouses in each country, we are perplexed by recent suggestions that the competing methodologies should be run simultaneously, with clearing members and clients then subjected to the model resulting in the highest margin requirement on any given day. This overly complex and operationally risky policy seems to overlook the implications to those who post the margin, the client and the clearing member. Assuming that each regulatory jurisdiction is unlikely to prescribe identical requirements, the practicality of requiring dual registration or recognition hinges upon the various jurisdictions' ability to acknowledge regulatory differences and coordinate a reasonable path going forward. I also want to briefly mention new reporting requirements that fall to clearing members. FCMs serve as the responsible party for the submission of various data sets to the CFTC, both for our own entities as well as for our customers. Recent CFTC regulations require FCMs to collect certain customer data that has never been expected before. Not all customers are willing to provide this new information, which presents challenges to FCMs, who are then put in an untenable position of either ceasing to do business with the customer or incurring regulatory risk. While we are happy to work with the Commission to improve the process surrounding new ownership and control reporting, some regulatory refinements are likely necessary in order for the data to be available and useful. Additionally, the Dodd-Frank Act requires new Chief Compliance Officer annual reports that are quite extensive. These reports are linked to the filing of annual financial reports, even though the two reports are very different and require different inputs from different parts of the organization. Given the complexity of compiling the Chief Compliance Officer's filings, it may be prudent to delink the two filings. Another critical area of focus for the FIA is Basel III capital requirements for our prudentially regulated members. While my clearing firm is not affiliated with a bank, those FCMs who are face a real challenge relative to excessive capital costs for their client clearing businesses, making it increasingly expensive for many clearing member banks to offer clearing services to their clients. At issue is the recently finalized leverage ratio, which treats client margin posted to a bank-affiliated clearing member as a resource that can be used to leverage the bank, an assumption that seems to conflict with requirements in the Commodity Exchange Act and CFTC regulations that require client margin to be segregated for the protection of the customer and thereby unable to be leveraged by the bank. The lack of recognition of the CFTC requirements in the context of the banking regulator's new capital rules results in increased costs to the clearing system, including clients of bank-affiliated clearing members, capital costs that exceed tens of billions of dollars today and hundreds of billions of dollars once more products are required to clear under the new swap clearing mandate. These numbers are staggering and frankly will result in fewer FCMs to support the overall clearing system and fewer choices for customers who need to hedge their risk. All effects which ironically seem contrary to the principles of the G20 and the Dodd-Frank Act, which are intended to encourage more risk mitigation from the practice of clearing. Over the 10-year period between 2004 and 2014, the pool of FCMs registered with the CFTC decreased by more than 50%, from 190 FCMs to 76 FCMs. The new capital requirements on bank-affiliated FCMs will only serve to further consolidate the pool of clearing services available to customers at the very time when more clearing is mandated. In closing, I'd like to remind the subcommittee that the FCM function has proven to be an essential foundation for managing risk in the futures markets and is integral for advancing the goals of the new trading and clearing requirements for swaps as well. We want to continue supporting the risk management needs of our customers in a productive way. This is a goal I know the members of this committee share, and I look forward to working with you as you consider the CFTC's role in achieving this mutual objective.
Thank you. Mr. Bernardo.
Thank you, Chairman Scott, Ranking Member Scott, and members of the subcommittee. My name is Sean Bernardo. I am the Chief Executive Officer of TPSEF, Tullett Prebond's Temporarily Registered Swap Execution Facility, or CEF. Tullett Prebond is a founding member of the Wholesale Market Brokers Association Americas, an independent industry body whose membership includes the largest North American interdealer brokers. I appear before you today in my capacity as a WMBA officer and board member. I am pleased to share with you the CEF perspective on CEA reauthorization and Dodd-Frank implementation. By way of background, I've spent nearly 20 years in the interdealer broker industry. My career began in 1996 as a U.S. Treasury broker. I've spent the vast majority of my career building various electronic and hybrid platforms in fixed income markets. As CEFs, WMBA member firms are the trading platforms that help foster liquidity. We do not hold securities or customer funds. CEFs are regulated intermediaries that work to match buyers and sellers of swaps. Congress fashioned the newly regulated swap market to foster competition between trading platforms in order to ensure that end users seeking to manage risk can do so effectively. There are 22 temporarily registered CEFs, with 3 additional applications pending before the CFTC. Furthermore, CEFs compete against one another for their customers' trades on price, service, and liquidity. I'd like to share 2 main points with you today. First, since the CFTC adopted final CEF rules in June 2013, the WMBA member firms have been working diligently to implement the new requirements and meet the standards necessary to obtain permanent registration. This, however, has not been an easy task. Second, the WMBA is encouraged by recent speeches by the CFTC chairman and commissioners, including Commissioner Giancarlo's white paper on swap trading rules, suggesting that the agency may consider adjusting various aspects of its CEF rules and swap trading regulations. Let me briefly describe WMBA member firm experiences as they relate to CEF registration. CEF applications have been pending before the CFTC since the summer of 2013. WMBA member firms have each filed registration forms, participated in many staff visits and calls, and responded to document requests, exhaustive questionnaires, and rulebook inquiries. And let me also say that the CFT staffers are hardworking, dedicated, and have been fully engaged in this process. The WMBA remains hopeful that the CEF registration will be issued later this year so that we can dedicate more of our resources to providing competitive, vibrant, and transparent markets. But CEF compliance remains challenging because the regulatory landscape continues to shift as the CFTC issues numerous no-action letters, guidance, and interpretations of the rules. I'd like to share one example from my written testimony that illustrates our concern with not only the nature of the CFTC's rulemaking process to date, but also the impractical burdens imposed by certain CFTC regulations. To the surprise of the market participants, a footnote to the final CEF rules, footnote 195, imposed an obligation on CEFs to collect the underlying master agreements between counterparties. In response to market participants' concerns to this footnote, CFTC staff ultimately issued no-action relief, which in turn imposed another unforeseen obligation on CEFs, which has proven to be unworkable. In sum, the no-action relief failed to provide meaningful relief to the industry. We continue to engage the CFTC staff on this point and hope the agency will resolve the issue shortly. But this approach to regulation fails to provide the legal certainty and stability needed for CEFs and swap trading to flourish. Second, as it relates to altering or fine-tuning the CEF and swap trading rules, in addition to the problems from footnote 195 I just referenced, there remain other pressing implementation areas that continue to frustrate the CEF's registration and swap trading process. My prepared statement includes a list of pending implementation issues that continue to delay the registration process. When the CEF rules were adopted 2 years ago, Commission has demonstrated a commitment to reassessing the policy judgments as the markets evolve and the CFTC gains more experience and new information. We urge the agency to, as both Chairman Massad and Commissioner Bowen have said, enhance the rules to fit the current market structure. Finally, as the Congress considers CEA reauthorization, the WNBA urges the committee to ensure that the agencies remain true to the CFTC's principle-based approach to regulation. Overly prescriptive rules will artificially restrict the flexibility that benefits all market participants, including the end users, and inhibit U.S. financial markets from remaining the most competitive and liquid in the world. Thank you for the opportunity to comment on these very important issues. I would be happy to answer any questions.
Gentlemen, thank you for your testimony. Yield myself 5 minutes for the first questions, and then we'll move through to Mr. Scott, and then rotate through the committee. Mr. Jackson, this committee has been examining growing difficulties with the cross-border application of new derivatives regulations for several years now. Do you see any cause for optimism that the CFTC and foreign regulators may come to any agreement?
Thank you for the question. And the short answer is yes, I do. The long answer is the reason I believe that is that the regulators, both in Europe as well as Chairman Massett and his team, are focused on the right thing, which is true equivalence. Because without true equivalence, you have an outcome where you can unfortunately create global disruption in the way that people are trading these markets, both in Europe and the US, because they are truly global markets. And second outcome could be what Mr. Corcoran referenced in terms of the operational inefficiencies and headaches that it can create if you don't have true equivalence. One other comment I'd make there is that when we're talking about true equivalence, where we are today it's not the same. The margin methodologies that are used in the clearinghouses are different and can create different outcomes. In the US, the model that's used is one-day gross. In Europe, it's two-day net. And there are scenarios where those do give you the same answer, or very close to the same answer. If you are a very large FCM and you have a portfolio of trades that have a lot of offsets that can be net against each other, yeah, you get much closer to that one-day gross answer. If you have a portfolio of customers that are market makers that tend to have positions that offset in their portfolios, your answer will be very close in one-day gross, two-day net. Where they're very different is if you're a much smaller FCM, if you're a much smaller clearing member that may have directional portfolio that doesn't net. There, you're not going to get the benefit of netting, and they'll be very different. Or if you're an FCM or clearing member that provides specialized services for hedgers, commercial hedgers, because those commercial hedgers, at the end of the day, are directional in nature when you look at their futures positions, because they're offsetting it against physical risks that they have. So for entities that have that type of exposure, they're not going to be able to net, and the impact of where Europe versus where the US is going to be is going to be quite significant.
Thank you. Mr. Duffy, I would ask you that same question.
Okay, I'll try not to say the same thing as Mr. Jackson said, but he's correct. Except for one-day gross is without question collection of higher margin than two-day net. And for some of the examples he gave you in the portfolios, but when you run most of these portfolios, which we've done for the European Union, we have showed them that we collect more money here in the United States under our margining regime. And for us not to be deemed equivalent, some of this cross-border nonsense, for lack of a better term, that's been going on for the last 2 years is becoming ridiculous. I think we're getting into a competitive trade issue, Mr. Scott. I think that entities in the European Union are looking for a leg up on U.S. institutions. I think that's inappropriate. There's no question that we will get this resolved. The question is when, but we should not let it go to a point where we keep pushing dates certain out in order to give one particular entity a leg up on another entity in a different jurisdiction. That's my concern, Mr. Scott, and I'm concerned that's where we're headed right now. So I'm not as optimistic as Mr. Jackson that we'll get there as soon as we should.
So with regard to preventing the regulators from finding common ground, it's a matter of European regulators trying to give an advantage to European.
European regulators said to us, sir, that we went to them, and what Mr. Corcoran said earlier, we want to have this higher of issue, but we even went to them and said, we'll accept the higher of whatever you want. Just tell us what you want. We'll accept that margining regime. The higher of 1 day gross versus 2 day net. They came back to us and said, that's fine as long as it only applies to the United States. So when you get a response like that, there's nothing more than a competitive issue that nobody has an interest in settling until you can get the entities in your jurisdiction a leg up on the U.S.
Mr. Jackson, what do you think is preventing the international regulators from finding that common ground?
I think they realize that at the end of the day, we need to have true equivalence. That what the exact models are that we use in the U.S. and when we determine what is the margin that's established for a particular futures position should be the same as what it is in Europe. And they're focused on getting to that end goal. And I know that Chairman Massad, from the conversations I've had with him, and that our team and our staff has had with the European regulators, that's the end goal that people are trying to get to. When it comes to
my time has expired, so let me, out of courtesy for the other members, let me turn it over to my colleague, Mr. Scott.
Thank you very much, Chairman Scott. Our committee here is very concerned about the importance of and the impact of the Basel III capital rule on clearing, especially the supplemental leverage ratio. I'd like to ask the committee to weigh in on this. Do you think that the supplemental leverage ratio will impact the futures business?
I'll be glad to answer that question and provide you the FIA feedback. The FIA that represents the Futures Commission merchants in this country has done extensive data collection from our members, and the answer to your question is yes, the supplemental leverage ratio is going to impact the ability to serve customers and the cost of customers in the United States. And we see that today already, that there's increasing price changes going to the end line client based on the leverage test. The leverage ratio, and I believe the Ad Committee has already sent a letter to the Treasury on it, is punitive to the bank-owned FCMs in the sense that it doesn't recognize that the margin funds on hand at FCMs are in no way able to be leveraged by the banks. And although the Basel Committee has taken many, many meetings with our constituents from the banking industry, we've to date have had no relief on this matter, but it certainly is and will have an impact on the ability for bank FCMs to provide customer service and customer products to their bank customers.
So could you tell us again, 1, 2, what would be the greatest impact? Where is that will be felt in the market real quick?
I think it's likely that there will be bank-affiliated FCMs exit the marketplace, and therefore we'll have fewer FCMs. It's just very, very difficult to get the return on capital that a bank is interested in receiving when you double the size of the capital contributed to the FCM for this product.
Thank you very much. Mr. Duffy, let me turn to you. I read your testimony, which was very good. You mentioned an important point that I'm working on, and that is to make sure that the CFTC is funded. And in your statement, you mentioned the importance of the CFTC having proper funding. Could you expand on that just a little bit and tell us why a fully funded commission is very important in terms of regulating this market?
First of all, we talked earlier, and in both of your opening statements, you talked about the growth of the derivatives industry, especially here in the United States, but globally. In order for the United States to remain in this competitive world that we live in and to prosper in this world, for people to do their risk management, we always need to have a regulator that has the utmost credibility to the marketplace. I'm a big, big believer in that, sir. And then to have them properly, funded from a revenue standpoint and also have a full complement of commissioners is also just as important to the credibility of that agency. The question has always been, Mr. Scott, as you know, how do we get there? How do you fund these agencies? Who's going to pay for these agencies? When you're looking at a multi-trillion-dollar a year budget that the government has today, I will tell you that for several $100 million, this serves a great public service to fund this agency at an adequate level, because if these spreads were ever to widen, the cost that would bear on the consumers, because the spreads widen and then the prices get skewed, could cost billions of dollars for the consumer. So it is important to fully fund them. It's important from a credibility standpoint on the global scale that we operate under today.
And would you care to, I know you follow this very closely, would you say at this point that the CFTC is adequately funded or would need more funding?
It's not for me to determine what is adequately funded. I will tell you that I think they've done a remarkable job through its history in regulating a business that's been growing at 20 to 25% on an annual basis over the last 30 years. So I will say they've done a great job.
All right. Let me go to you, I believe, Mr. Roth. You mentioned in your report that I guess it would be sort of outsourcing, that you do some outsourcing work for the CFTC. I want to put that in this context of funding and making sure the CFTC is operating, given the fact that you do both regulating your own and enforcing your own members for your group. You also work and do work for the CFTC. How would you juxtapose this in light of the funding appropriateness for CFTC?
Well, it's interesting, Congressman, if you take a historical perspective, back when NFA was first formed, the very purpose of forming it was to relieve the Commission of some of the stresses that it was feeling back 30 years ago. And that was part of our original design and our original purpose, and it's remained one throughout our existence. So we work very closely with the Commission, all the divisions of the Commission, not just on those where we've got formal delegations. We're in daily contact with the Commission, and including the Chairman's office. We've had recent discussions with the Chairman's office initiated by Mr. Massad, looking for other ways in which the Commission can make better use of the resources of NFA and the CME and other SROs.
My time is getting short. My point is, I would wonder if you might care to just say, given your intimate working with them and that staffing, you would have some inside knowledge in terms of your own thought as to their funding level being sufficient or not.
And Mr. Chairman, again, there are our oversight agency. We're not theirs, but I can tell you these are very challenging times for regulators. You can just look at what's happened to our budget, where our budget has doubled over the last 4 years. So I understand the stresses that they're going through.
Mr. Lucas.
Thank you, Mr. Chairman, and I appreciate you and the ranking member for holding this meeting. I agree with both of you. We accomplished a great deal in the efforts to try and reauthorize CFTC in the last session of Congress, and that was a period of time that was a little bit difficult to get anything done, the Farm Bill being a classic example. In this case, we did our work, but the other body couldn't quite get there. So that means to our panelist friends, we have to start all over again. A certain amount of these questions and observations you've discussed time and time through the whole process, but one more time. And I know, Mr. Duffy, that you're a mild-mannered, timid fella, but I believe in the reauthorization process, when the phrase user fee or transaction tax came up, I watched your eyes dilate. Could you, for the record, as we begin this process again, if you have any kind of a timid opinion of that, offer it to us?
Well, again, sir, user fee transaction taxes are the most penny-wise, dollar-foolish thing you could ever have in an industry such as ours. We're not talking about millions of market maker participants, or like they have in the securities world, where you could charge a fraction on a trade for a trade that's going to go on for days, weeks, months, or years, and so it really isn't hit. We have people creating liquidity so folks could do risk transfer. And we're talking about a very small universe of those people creating that liquidity. If you take their cost of business and add 30 to 40% in order to fund an agency, I assure you they'll take those spreads and widen them. That would damage the markets immensely for the good folks of Oklahoma, for the other people around this world that are trying to put food on the tables of American people and shipping it overseas at a cost-effective rate. To give you an example today, the corn yield in Iowa and the corn yield in Illinois last year alone were record levels. We could take corn at $3.30 a bushel, add $1.50 on it, and send it to China for half the price they're growing it today. We didn't do that. But if we don't have efficient marketplaces, those markets will get skewed and will have the same prices as other countries around the world. So it is incredibly foolish to go down a path of trying to introduce a tax on a small tax on a very small population of people, which will damage the spreads immensely. Thank you for the question.
Thank you for clarifying that question as we begin this new process. And I'll go back to you again, Mr. Duffy, and anyone else who wants to comment on this. But let's talk for a moment about the equivalency issue. And you mentioned the June 16 as being a critical moment. If this issue is not addressed, capital is a very fluid thing in the world we live in. How fast does the situation begin to deteriorate?
We're already seeing clients today, sir, look for alternatives outside of the United States. That's not a good thing when you're in a global market, especially when they're looking at alternatives that are in Singapore or other parts of the world that are no different than what the United States is offering today. To me, this is a very large slap in the face to the United States of America by the European Union by not granting this equivalence when they're prepared to grant equivalence to much smaller nations with the same type of regimes that we have here in the United States. This is a big deal for us. We need to get it done. The uncertainty of it, sir, is more important. You're going to hear how we're going to push a date out, not to worry about it, we'll get it done, we're making progress. That doesn't do an end user any good when he's going to date certain because he knows there's another date yet to come. It's no different than Dodd-Frank, sir. We addressed this when you were chairman of the committee. We have to have certainty. Whatever the rules are going to be, let's have certainty. And to have this uncertainty around what the regulations are going to be and who can play at what cost is not good.
Therefore, if we don't manage it well, we could damage what has traditionally been a very strong industry in this country for a generation.
It doesn't take much to take a kink out of the armor in any particular market, especially something like our market. It's based upon an ecosystem that includes all. And when you start to take pieces out of it, it becomes less efficient. When it becomes less efficient, the costs go up. So it doesn't take much, sir.
Sounds like, Mr. Chairman, on a lot of things, time is of the essence, and I'm proud we have a good pair of leaders on the subcommittee. Yield back the balance of my time.
Thank you, Mr. Chairman. Ms. Kirkpatrick.
Thank you, Mr. Chairman, Ranking Member Scott. Gentlemen, thank you for your testimony here today. I'm a former prosecutor, and so my questions are going to be about enforcement. And how much of what the Commission's enforcement actions do you think are seen just as the cost of doing business? I mean, do you know what I mean? So that bad doers can just factor it into the cost of doing business?
Yeah, maybe I could talk about that a little bit. Obviously, I can't speak for the Commission, but I can tell you that it's way more than the cost of doing business because the CFTC and NFA together meet on a quarterly basis with representatives of the U.S. Attorney's Office and the FBI and postal inspectors to tell them all about the fraud cases that we've worked up and to try to get the most effective thing you can do for fraud is put people in jail. Prosecutorial resources, as you know, are so scarce, but we've worked very hard to build those relationships, and we've had a significant increase in the number of criminal prosecutions that are resulting from violations of the Commodity Exchange Act. So for those people that are committing fraud, they're risking more than the cost of doing business. They're risking their liberty.
How effective do you think the enforcement actions have been since 2009 then?
Well, that's always hard to measure, isn't it? You know, from my own perspective, sometimes I'd prefer to see enforcement cases go down if it meant that compliance was going up, rather than cases that are just being missed. But overall, I mean, certainly I think the Commission's cases on LIBOR have had tremendous impact around the world and as motivating further reform. So I think the Commission's done a fine job in that area, and I think overall the enforcement cases are having an impact.
Any other members on the panel wish to comment on that?
I would, if you will,
Corker, yeah.
on behalf of the FIA and also our organization, R.J. O'Brien and Associates. In no way do we think enforcement is a cost of doing business. We respect the rules and we invest greatly in the law and compliance factors in our organizations, and I know our member firms at FIA do as well. Our brand name and our brand value is important to us. It's important to our clients. And running a business according to the rules is paramount to how we operate. So I don't see this as an issue in the industry is enforcement is a cost of doing business. It's taken very, very seriously. No one wants to see their name in a press release from the CFTC enforcement action, and I think the enforcement actions that have taken place since 2009 have reinforced the need for all FCMs to take a strong look at how they operate their business and take responsibility for it.
Do any of you see ways that the enforcement actions can be improved? Any comments on that?
I don't mean to...
It's open to the whole panel. So if anybody has any thoughts, I'd like to hear from
but
all of you.
sometimes when I just talk more than everybody else. But there are, I think, and I'm sorry to be self-serving here, but the building of those relationships with prosecutors all around the country is really, really key. In our experience, sometimes when you'd have a good case of fraud and you bring it to a local prosecutor, when you mention the Commodity Exchange Act and derivatives trading, their eyes glaze over and they quickly lose interest. So part of it is educational, and it's not just working with the individual prosecutors on individual cases. We're also part of an anti-fraud working group that the Justice Department puts together so that we can meet as a collective body frequently throughout the year and try to educate them, because these cases, a fraud case is a fraud case, and we hope they're not deterred because it can sometimes be a little bit arcane. But I think we've made a lot of progress in that.
But more training for prosecutors would help, is what you're saying. These are somewhat complex cases.
We don't want them to panic at the phrase derivatives trading. It's fraud. If you can get like certain jurisdictions like Chicago, they're very comfortable with these cases because they've done them. You just have to overcome those barriers in jurisdictions where they haven't brought as many cases.
I have about 40 minutes left. Seconds left. Anybody else want to comment? 40 minutes? I wish, Mr. Chairman. 40 seconds. Anyone else? On improvements. Okay, I yield back my time. Thank you.
Thank you. Mr. LaMalfa.
Thank you, Mr. Chairman. Of course, one of the key issues we're concerned with is the ability for end users to have the access to the market, and the difficulty we're seeing with many of the rules that Dodd-Frank has offered and CFTC is trying to sort out. But let me come back to Mr. Roth, and we'll follow up Mr. Corcoran too, on the issue of the number of FCMs that are available, that are in place, declining. And so if you're concentrating more and more work, more and more risk into fewer and fewer, that limits options for end users as well as everybody in the market. What do you think, what problems does that really pose that we can hear today here in committee?
Well, Congressman, I think that's an honest-to-God issue. I mean, Mr. Corcoran made a reference to the consolidation that's occurred over the last few years. If you go back, I started NFA a long time ago. We had over 340 FCMs. So the consolidation has been dramatic.
340?
340.
What do you think that number is today?
So, well, Jerry mentioned, it's about 73, I think.
73, was it? Okay.
So, and it's very scary because you're concentrating more risk in fewer firms. And, if you take a look at your constituents, the number of FCMs that service ag producers and ag end users, that's a real small subset of the 73. So they have fewer and fewer choices, which isn't healthy for them from either their choices or their risks. So I think we have to be, as regulators, have to be very, very sensitive to the regulatory costs that we impose with any sort of rule. Chairman Massett, I've had conversations with him on this topic, and I know he feels the same way. So I think consolidation, when it's a result of business evolution and business competition, that's one thing. I never want to see the regulation having an undue impact on consolidation.
Mr. Corcoran.
Yes, thank you very much for this. It's been very difficult times for FCMs. As far as R.J. O'Brien goes, we're an independent FCM, so we're not owned by a bank affiliate or any other large corporation, so we have to make ends meet on our own. I would say that law and compliance and regulation has been a big investment of ours over the last 3 or 4 years as the rules have evolved. And I would say many of the rules were tremendous rules when it came to customer enhancement and protection. However, the burdensome of continuing compliance with the rules is ongoing, and we find ourselves investing millions of dollars in law and compliance in our organization just to meet, in some cases, very mundane regulation. But I also add that It just isn't law and compliance that is a challenge to independent FCMs. It's technology investment as well. This industry has become very, very technology focused and intensive, and cybersecurity is now obviously a very, very important part of the food chain as well. And so it's difficult. I don't see how we're going to get new participants in this industry because it takes large scale to be able to cover the cost structures of an FCM today. And so what we want to do is make sure we don't lose any more FCMs, because the capital structure of FCMs is the foundation of this industry, and it's important not to lose any more members.
Great. Thank you. Mr. Jackson, yesterday in our subcommittee, amongst the different subjects, was the hedge exemptions. We want to have bona fide hedge exemptions that, please talk a little about the process in the granting of those, but also please follow up too with the interpretation that is happening by CFTC of that. Is that a problem area, and do you think Congress should be intervening on that in helping to be more explicit on what a bona fide hedge is? Would you touch on those two things, please?
Yes, thanks for the question. And the answer to your second question is yes. I think that Congress should get involved in making sure that what's being interpreted now in the rulemaking of the narrowing of what qualifies as a bona fide hedge is a deep concern to commercial market participants. And let me give you a very specific example. Just a couple of weeks ago, I brought around to the CFTC to meet each of the commissioners a gentleman from Hershey's. So cocoa is one of the products that trades on our exchange. You think of Hershey's. And what they were talking about in bringing forward to the commission is the unintended consequence of a typical hedge that they do, where a chocolate company, what are the times of the year where they make most of their money? They make most of their money selling products around Halloween, Christmas and the holidays, Easter, Valentine's Day. And when they negotiate contracts with the big shops like Walmart or Costco, they're negotiating those agreements 18 to 24 months in advance. And one of the interpretations that's being done to narrow it is that you can't hedge your risk, consumption or production risk, more than 12 months into the future. And for them, Hershey Company is sitting here today negotiating contracts not for what a chocolate pumpkin is going to look like and what it's going to be priced at for Halloween this year. They're talking about 2016 and 2017. That's one example as it relates to chocolate. You can go through, and I'm sure Terry can do the same, and go through examples in every single one of our industries around what this narrowing definition of what constitutes a bona fide hedge and what the material impact is going to be to standard practices that have been used for a long, long time. And at the end of the day, that means higher prices for consumers for these goods.
So the flexibility you need to plan your product is taken away because of the short window.
Yes.
Yeah. Okay. Thank you. I better yield back. Thank you, Mr. Chairman.
Thank you. We'll go to a second round of questions if any of you have more questions. I've got a couple for you, Mr. Bernardo. Some have suggested that laying futures market style rules over the unregulated swaps market was a mistake. Do you agree with this assessment? And how are swaps markets different from futures markets?
I would agree that you can't take futures market regulation and lay it on top of the OTC derivative swaps market. The markets are very, very different. You have, in futures, you have a lot of clients trading much smaller amounts of sizes, and the number of transactions per day is very, very high. In the OTC swaps market, you have a number of, not as many clients trading very, very large sizes, and it trades much less infrequently. You could have products that trade a couple of times in a week. You could have products that trade a couple of times in a month. So taking the regulation from futures and attempting to put it into the swaps market has not worked out very, very well.
You've commended the commissioners for their willingness to consider potential revisions to its Dodd-Frank Act regulations. Could you please share with the committee specific recommendations that a commissioner has offered which you think should be implemented and why that should be implemented?
I think the fact that the commissioners are willing to further review the rules and realize the impact that some of the current regulations are having on the marketplace is terrific. We welcome that. We've been working with staff over the past several years, and we'll continue to work with them on the issues that we are experiencing with the implementation of these rules.
The no action relief letters, interpretive guidance, those types of things, compliance with in those areas, I would think that would be pretty difficult to know
It is
exactly
difficult.
what you were supposed to do.
Agreed. It's the fact that it creates the uncertainty in the marketplace and it creates instability. One, it will push or can push liquidity offshore, which it has, because if we have prescriptive rules, which we currently have, what happens is you're dislocating the global financial markets. So liquidity that would have remained here in the U.S. is being pushed offshore. By that happening, inevitably, less liquidity in the market, the pricing is not as good, and inevitably the end user is going to be impacted by that. Euro interest rate swaps is a perfect example. I think in the past 15 months, ISDA has done a review of that particular market, and roughly 77% of that volume has moved offshore. So inevitably that is going to impact the end user because less liquidity means worse pricing.
Well, thank you for that. I'm going to yield the remainder of my time, and then I'm going to go to Mr. Davis, allow him to ask questions, and then we'll come back to Mr. Scott as well for a second round. Mr. Davis.
Thank you, Mr. Chairman. Thanks for having this hearing. It's great to see many of you on the panel again in front of this subcommittee, and also when you appear in front of our committee. But your presence also means that there are still issues that we have to address as Congress. And that's why I think the testimony of each and every one of you today is extremely important to what we can do when we craft our proposals. So with that, I'll get right into the questioning. Mr. Duffy, good to see you again, sir.
Nice seeing you, sir.
I want to ask about the issue of clearinghouse risk. Some market participants are calling for clearinghouses to increase their contribution or their skin in the game to the so-called default waterfall in the event of a clearing member default. For the benefit of the committee, can you describe to us what sort of cost impact an increased contribution requirement would have on your clearinghouse or any clearinghouse?
Well, today we already do have a contribution to our default fund. We have the largest contribution of any exchange in the world. We're roughly around $400 million of our money into that default fund. And it also comes before any of the clients. So if there's a default, it's the default in client, it's CME, and then it comes to the clients behind them. So we're in front of all the other clients. What's interesting about some of the calls for increased skin in the game, as they're referring to a congressman, is it could cause a bunch of different issues. First of all, we don't introduce risk as exchanges. We manage risk as exchanges. So we don't bring it. We manage it. So I think there's an inherent difference right there about how we should have it. You have to look at the entire regulatory regime that we operate under. I think Chairman Massett said it well in a recent speech. There's more to skin in the game than with the whole regulatory regime. The other thing that always concerns me about when you put more skin in the game is always there's a potential moral hazard. So if I was to put up more money and you were able to trade bigger against my dollars, does that introduce you to act in bad behavior because you know you're not putting your funds at risk, you're putting my funds at risk first? That's a concern, that's a moral hazard. That's a moral hazard to the other participants that are in the default fund below me also. So these are all things that are very concerning when people call for this, just saying that they should, CCPs or clearinghouses such as ours or the Intercontinental Exchanges should have more skin in the game. We have, as I said, close to $400 million today. We think we have adequate skin in the game. We don't introduce risk, and this would put a huge burden on our system because we don't even know what the number of people are saying is put more into that system is.
Now, thank you, Mr. Duffy. Mr. Corcoran, I had a brilliant question set up for you, but somebody else asked it. So you got to.
Am I off the hook then?
You're off the hook. You're off the hook. I actually going to go back to Mr. Duffy. So, hey, Terry, can you? Yesterday we had a hearing in this subcommittee, and an end-user witness testified that he believed futures exchanges were opposed to position limits because such limits would reduce trading volume and therefore an exchange's revenue. Is there any merit to this claim?
No, absolutely not. Futures exchanges are not opposed to position limits. Matter of fact, today, sir, we have hard limits on all of our agricultural products because they're government mandated. On our energy contracts, we have hard limits in the spot month to make sure that we manage so there's no congestion. And then we have accountability levels. So for someone to say that we would be opposed to position limits because we want to put the trade in front of the credibility of the marketplace is ridiculous. I've said this since I've been chairman of this firm for 14 years. If we don't have a credible marketplace, we don't have a company. And that is the most important factor to the CME Group and me as the chairman and president of the firm that I will always say throughout the organization. We put nothing in front of the credibility of our marketplace, and position limits and accountability levels are a component of that.
Well, thank you. And Mr. Jackson, you run a futures exchange. What's your response?
Thank you. I'd echo a lot of what Mr. Duffy said, as I think he's spot on there. Is at the end of the day, one of the most important roles that we have as exchange operators is to make sure that our futures contracts facilitate convergence for the futures price to where the physical prices are. So we're incented to not have manipulative activity going on. We're incented to have an orderly market, and like Mr. Duffy has position limits in place, we do as well at the Intercontinental Exchange.
Well, thank you very much. Thank you to each and every one of you. Again, great to see many of you again, and I yield back the balance of my time, Mr. Chairman.
4 seconds. Thank you. Mr. Scott.
Thank you, Mr. Chairman. Over a period of time, we've had this issue of the definition of U.S. person dealing with cross-border. As I mentioned in my opening remarks, this derivative swaps market is global. And about a year and a half ago, I think it was in July of 2013, the CFTC issued its final guidance setting out the scope of the term U.S. person. The general framework for swap dealer and MSP registration determinations, the treatment of swaps involving certain foreign branches of U.S. banks, and the treatment of swaps involving a non-U.S. counterparty guaranteed by a U.S. person or affiliate conduit. Now, I'd like to get your thoughts on this definition of U.S. person. How have you all and the market itself been affected by the Commission's guidance defining who is a U.S. person?
I guess I'll start on that. And to your point, Congressman, the markets are global. So by having the distinction between a U.S. person and a non-U.S. person, what we've experienced is an impact on the liquidity in the marketplace, and what we've seen is clients and/or firms that are also global and have a U.S. presence as well as presence overseas, they will opt to do business in a under less prescriptive regime in Europe and/or in Asia. And we've seen that happen across multiple products, and we've actually been told by those very customers that the reason they're not trading in the U.S. with us at this point is because the rules are less prescriptive away. So the markets are global, as you said, and inevitably you're dislocating the marketplace. So those liquidity pools that were operating 24 hours and the U.S. looked upon as one of the liquidity pools where they could get business done, they now choose to do that business overseas.
And so going forward, what recommendations could you make to the CFTC to give greater clarity on this whole definition of U.S. person? It just keeps coming up.
I think it's important not to just do it for the definition of U.S. person or non-U.S. person. It's important that the rules overall are flexible. So if we have flexible rules in the U.S. as we currently do overseas, you won't see as much liquidity move away from our shores, which inevitably will hurt the U.S. economy. It will take away jobs. I think that the staff, although working very, very hard as it is now, needs to consider more flexible rules, which, again, we welcome.
All right, thank you. Let me ask the panel, too, that comes up all the time about enforcement and of the CFTC. Many complaints that any enforcement action of the Commission have yet to produce any prosecutions for senior managers of any of the major financial firms that have been engaged in misconduct. There's public awareness and public pressure that with all that has happened within this area since the meltdown of our financial system, and there's been wrongdoing, but there's been no persecution. No one has gone to jail, and you all have heard that as well. So let's weigh in on that. How much are the Commission's enforcement actions seen, for example, as a cost of doing business? And how do we rectify this situation? How do we improve the enforcement strength of the CFTC?
Thank you. You know, I think the CFTC's enforcement program has been very vigorous, obviously, over the last several years. And you're right, and a little discussion we had earlier just mentioned that, from my point of view, the ultimate deterrent to violations of rules where it involves fraud is legal enforcement action, prosecutions. Criminal prosecutions have infinitely more impact from a deterrent point of view than civil sanctions. Now, the CFTC, I think, has the authority to bring civil actions, but obviously they have to work with criminal prosecutors to bring in those types of criminal prosecutions. And obviously those burdens are difficult. It's intentionally a difficult burden to prove, to deny somebody their liberty. I'm not privy to the proof that the Commission has in those cases, but I know that their overall sentiment is to build the strongest case they can and work with prosecutors to achieve prosecution where they can. But those there is inherently a difficult burden of proof in bringing a criminal case.
Let's say personal liability regime for a senior manager, for example, at a clearing members who do nothing to stop reckless, manipulative behavior on their watch. Now, in England right now, they are setting a rule that they're contemplating to deal with a situation like this. Are you all aware of that?
I think, Congressman, I'm aware of the failure to supervise, and I think that's kind of what you're referring to here a little bit, what some of the FCMs have done historically. And we have seen charges brought against FCMs historically over the last 20 years against failure to supervise, even when they have people out in the country that they're supposed to be overseeing, which sometimes they don't have a hands-on ability. Mr. Corcoran obviously has a lot of offices throughout the country. He's got to supervise those, and he has an obligation to do so. It's a very difficult process, but I do think we are seeing the enforcement of the CFTC, to Mr. Ross' point, take hold when you look at what happened at Peregrine Financial, when you look at what happened in other instances. But I think the public, to your point, is looking for someone to stand up and accept blame, and someone's got to put them in jail. So whether it would happen with MF Global, whether it's happened with the fixing of LIBOR, foreign exchange, and every other benchmark, what's going to happen with this? Yeah. And I'm not a prosecutor. I don't know. I think Mr. Routh is right. I think it's a little out of the CFTC's realm, and they need to work with the government to process these people.
I need to move on to the next round of questions, if we may. Mr. Davis.
Mr. Corcoran, my brilliance is back. I found a question for you. You've expressed concern regarding the U.S. and foreign regulators' failure to coordinate their regulation of your markets. Do you believe that dual registration and cooperative oversight is a viable means to regulate clearinghouses?
Dual registration is not necessary, in my opinion. I think Mr. Duffy and Mr. Jackson are better suited to speak to this, but it seems that we're very, very close to solving the equivalence issues, and it's boiled down to how we collect margins from customers. And, you know, just a recognition that each of the jurisdictions have adequate safeguards for CCPs, it should be able to recognize the ability to get this done.
Okay, does the CFTC staff, their staff's use of letters to issue individual exemptions to a limited number of foreign clearinghouses provide enough clarity and certainty to market participants? Or is there a better solution?
Not necessarily. These letters do not provide absolute certainty to the participants on a going forward basis, and sometimes come far too late for the market participants to anticipate approval or not approval. And so it's better to be done at the senior levels of the regulatory regimes and get this done without letters.
Okay. Well, thank you. And my question now, actually, we'll start with Mr. Roth, and then Mr. Duffy, if you'd like to jump in, and Mr. Jackson, too. Obviously, the CFTC is an agency that we know we have to go through the reauthorization process, and part of our job as policymakers is to ensure that any mandates that are imposed by us are working correctly. And in an effort to help free up some resources at the CFTC, you know, Congress, we're able to eliminate mandates that may not be necessary and shift more responsibilities to more appropriate parties like yours, Mr. Roth. Are you aware of any obligations that Congress has required the CFTC or what they've undertaken which may no longer be needed?
Congressman, what we've been doing in conversations with Chairman Massett and with the Commission staff and with the CME is trying to identify those situations where there are activities that are being performed by both the CFTC and an SRO, whether involving reviewing monthly financial statements. There's a myriad of activities that the CME and NFA both engage in on a daily basis, and the Commission staff expends resources in those areas as well. And what we're trying to do is eliminate duplication of effort, and that's a multifaceted. It's not just between the CFTC and NFA or the CME. It's also in the swaps area, for example. We're trying to coordinate with so many of our swap dealer members are banks regulated by several different bank regulators. We're trying to coordinate activities with them so that we don't duplicate efforts. No matter how we fund the CFTC, regulatory resources are always going to be precious, and we can't afford to duplicate efforts when we can avoid it. And so we're trying to work with the Commission to eliminate that. We're trying to work with bank regulators to achieve the same goal.
Has Chairman Massett been cooperative in reducing some of these duplicative efforts?
He's been more than cooperative. He's initiated the discussions in some cases.
Great.
I mean, he's certainly aware of the constraints on his budget and looking for creative ways to deal with them. And we've had a great working relationship.
Thank you. Mr. Jackson.
To add another area, when it goes to the interpretation of what is the role of the CFTC, especially in granting hedge exemptions for non-enumerated commodities, in the proposed rules, now the CFTC would take that responsibility away from the exchanges like mine and from Mr. Duffy's exchange. I think in the comments that I made up front, the decades of experience it takes in working and interfacing with each one of our commodity market participants to understand the nuances of each one of those, it's a big undertaking that the CFTC would need to undertake to ensure that they're not disrupting a commercial entity's ability to hedge in a timely manner by taking on that responsibility. And by doing that, they're going to need more funds and substantially more staff if that's where this lands, as opposed to the way it works today.
Excellent.
If I could just add real quick, Congressman, two things. I will say something that former Chairman Frank said in the Financial Services Committee to me one day several years ago. He asked, why should the exchanges have a DSRO at all? I said, if we have to have a DSRO to do the risk management. So even if you gave it to somebody else, you'll duplicate the cost because we're going to do it just for the risk management needs. So there's certain proposals that Congress or a government agency may think of that somebody else should do and not us. That adds a burden of cost to the government that doesn't need to happen. That has not happened. Second of all, on the position limits regime is a great example. We have the expertise in to set these position limits. It goes back to your earlier question. The credibility of our institutions are out there, and they're for everybody to see. We need to make sure that we continue to manage this position limits issue and do it in an effective way that takes the burden away from the government and the cost away from the taxpayer.
Thank you. My time's expired.
Ms. Kirkpatrick.
Mr. Bernardo, I want to follow up on your statement earlier about the fact that clients and customers are going to other countries rather than staying in the U.S. market. Can you expand a little bit more specifically for me on why that's happening?
Well, it's happening for several reasons. One, because of the prescriptive nature of the execution rules that are in place.
Is that the CFTC rules?
Correct.
Primarily? Okay.
Because of the uncertainty that's been created and the constant letters that are coming out from the CFTC staff, it makes it very, very difficult for them to consider executing in our marketplace going forward, as opposed to going to overseas where the regulation is not as stringent or not as prescriptive, or if they don't want to be considered a swap dealer or whatever the case may be, they're going to go and execute their business where the rules and the regulations are much more flexible. So by having prescriptive rules, we're actually pushing business offshore.
What would be your top 3 recommendations to this committee of something we could do to help level the playing field for our companies?
I think the top thing to do is to do what's been said that we are going to do, which is they're going to look at the rules again and create more flexible rules so you can take some of that uncertainty and instability out of the marketplace.
Anyone else want to comment on that? Any ideas about how we can make our companies more competitive? Can you give me some examples of what kind of flexibility you'd like to have in the CFTC rules?
For instance, to continue to follow the any means of interstate commerce rules, where your means of execution are flexible. There are multiple modes of execution that we currently use now. If you limit those modes of execution, you could limit the innovation that's to come in years ahead of us. So right now we use voice, electronic, and hybrid means of execution. We use auction platforms or algorithmic matching engines to transact business. If you tie prescriptive rules around those execution modes, we're gonna hurt innovation, and inevitably, I think you'll hurt liquidity.
Okay. Thank you for offering us this guidance, and look forward to working with you as we go through this process to make it better. Thank you very much. I yield back.
Thank you. And before we adjourn, I invite the ranking member to make any closing remarks he has.
Well, thank you, Mr. Chairman. This has been a very interesting and very important hearing for us all. We look forward to putting together our legislation coming up that will be very similar to 4431. We have many, many issues to deal with, to grapple with, to make sure we're cleared. We have the cross-border, we have the push-out, we have to still work with the areas in getting the SEC and the CFTC to jointly rule appropriately. Of course, as I mentioned before, we want to keep our eye on making sure the appropriations level is there for the CFTC. And as I said at the very beginning, you all out there, CME, ICE, all of the exchanges, the clearinghouses, you're the guys on the playing field, and we're more like the referees and the umpires here. So we have to work together. We look forward to it. And Mr. Chairman, it's a pleasure working with you on this committee, and we look forward to moving this issue and handling Section 7 of Dodd-Frank with good progress moving forward. Thank you, Mr. Chairman.
Thank you. I want to thank all of you for coming. These are complex issues, and as you've said, the integrity of the markets are extremely important to you. They're extremely important to us. We need the people who are using those markets to believe in them. And so, as we work to balance that integrity and access of those markets, we will be continuing to rely on experts like yourselves for that input. I think that, and I have every hope that we'll have a very good piece of legislation that will be bipartisan, that will be allowed to move through the House of Representatives and hopefully through the Senate, that reaches that balance between access and integrity. With that said, under the rules of the committee, the records of today's hearing will remain open for 10 calendar days to receive additional materials and supplementary written responses from the witnesses to any questions posed by a member. The Subcommittee on Commodity Exchanges, Energy and Credit hearing is now adjourned.